Good day to all our viewers and welcome back to another What If video. My name is Viap here and as always it is great to have you. Today's topic is what if an employee accumulates excessive annual leave? Does the employee forfeit the excessive leave not taken? Now, as always, to kick our discussion off, let's look at what our legislation says and thereafter look at what our court says on this topic. The legislation applicable in our discussion is the Basic Conditions of Employment Act, specifically Section 20. Now, Section 20, subsection 4 states the following. An employer must grant annual leave not later than 6 months after the end of the annual leave cycle. Now, what is an annual leave cycle? Well, we need to look at Section 20, subsection 1, where an annual leave cycle is defined as the period of 12 months of employment with the same employer immediately following either an employee's commencement of employment or the completion of the employee's prior leave cycle. Now, in interpreting the two sections that we have just discussed, it does appear that employees must take their annual leave within an 18-month period. The question, however, is what happens to annual leave not taken within the 18-month period? Does the employee lose it or does it remain available to take at a later stage? Now, this discussion is important for all employers. One, because if an employee does not forfeit annual leave, it creates financial liability. If you have an employee with long service who does not always take all his or her or their annual leave days, after 10, however many years of service, they may have an annual leave balance of 30, 40, 50 days. Not all employers will be able to pay that out. Also, from a financial point of view, an employer is obligated to report on it in its financials. So in terms of your bottom line, accumulated annual leave that is not forfeited might make the numbers look a bit skewed. So let's unpack what the Labour Court says or said on this topic. So I'm going to discuss three cases. The first two cases dates back to 2003 and 2004, and the third case is a 2014 Labour Court matter. The first case is the UXA versus Cola Packaging Limited, and in this case, the court held that the statutory annual leave not taken by the 6 month following the annual leave cycle in which it was accrued is forfeited. In other words, so statutory annual leave, first and foremost, we only refer to the 15 working days that is provided or granted through the BCEA. So that is statutory annual leave. The court made it clear that the statutory annual leave that is not taken by the 18th month will be forfeited. Then came the Jardine versus Tonga Hewlett Sugar matter, and in this case, the court held a different view, and the court found that the statutory annual leave, in other words, the 15 working days or 21 consecutive days, those leave days not taken is never forfeited, and it may be carried over to subsequent annual leave cycles. So definitely two conflicting judgments. Luckily, again, for us, in 2013, this conflict was resolved. And this matter is the matter between Ludwig versus Rural Maintenance. And in this case, the court considered the two conflicting decisions when it had to determine whether an employee who had worked for the employer for 27 months and who had not taken any annual leave was entitled to be paid upon termination in respect of all the annual leave that had accrued to him over the two annual leave cycles. Now, in this matter, as we would expect, the employer argued that the leave was forfeited, and the employee obviously argued that the leave was not forfeited. So what did the court look at? The court firstly considered the purpose of the BCEA, and the court held in this regard that if employees were entitled to accumulate leave indefinitely and also claim payment on termination, it would undermine the purpose of the BCEA, which is to ensure that employees take their annual leave and have a break from work. The Labour Court in this matter also preferred the UXA decision, and it held that annual leave not taken within the annual leave cycle or within 6 months thereafter shall be forfeited. Now again, the stance currently is that annual leave not taken in month 18, accumulated in an annual leave cycle and not taken 6 months or within 6 months thereafter, shall be forfeited, which interpretation or approach favors employers. But it's important to note that this approach or our discussion only applies to statutory annual leave. In other words, as I mentioned, the 15 working days or the 21 consecutive days. When we talk about non-statutory annual leave, that is those annual leave days granted in excess of the statutory minimum. In other words, you grant an employee 18 days working days annual leave, 20 working days annual leave, 25 days annual leave, whatever the case may be. Our discussion is not applicable to those leave days granted in excess of the statutory minimum. If you grant a non-statutory annual leave, it is recommended that an agreement be put in place that deals with the forfeiture of non-statutory annual leave. And an employer is within its right to, in this agreement, state that this annual leave can be forfeited at any stage, even at, let's say, month 13, for example. Now, in light of what we've discussed, I hope that employers can see the importance of just going back, reviewing your policies and contracts, especially when it comes to annual leave, and make sure that you have relevant clauses in place that deals with the forfeiture of annual leave. Now, ladies and gentlemen, that then brings us to the end of this video. Should you need any assistance in the review or reviewing of your contracts and policies, please do not hesitate to contact us. Until next time, bye-bye.